You've given them 3 weeks. We haven't removed them. If they haven't filed a habeas petition yet and your stay is lifted, then they can't make a screeching claim that they didn't have notice or opportunity. So you, Supreme Court, should deny the application and you should vacate your injunction that you issued 3 weeks ago.
So when Secretary Noem terminated TPS for the illegals that Biden flew into the country, when courts stepped in, they were violating explicit language that Congress had enacted, saying they have no jurisdiction.
Will the Supreme Court finally do something? We are now getting Trump and the Trump administration sending in this supplemental memo. They're saying, hey, Supreme Court, we've already been here for like 3 weeks now, and we need you to do something in this case of the AARP applicant. And this is not the American Association of Retired People. This is a person, right, who's going under a pseudonym since the judges are allowing terrorists and illegal aliens to proceed anonymously and get protections as class members against deportations, which is shocking, I know. But this is in the Supreme Court case. A lot of the stuff has been consolidated, and D. John Sauer is saying to them, listen, you, Supreme Court, issued an order saying we had to pause all of our deportations. Remember this? We've talked about it a lot. Pause the deportations until the courts of appeals and everything else can kind of figure it out. Well, we paused it, all right? And we've been waiting here for a long time to get this back on so that we can continue our deportations as necessary. And the Supreme Court has not been doing anything, just been hanging out, lounging around on their booties, just allowing the deportations to remain halted. So D. John Sauer's not happy about it. He said, all right, listen, you know what? John Roberts, Amy Coney Barrett, and the rest of you, over 3 weeks ago, on April 19th, 2025, this court entered an order, you, Supreme Court, barring Trump and the government from removing any member of a putative class of aliens. Remember, it wasn't even a formal class. The Supreme Court also said, yes, basically a class of gangbangers, or whatever, putative, meaning it hasn't been officially adjudicated yet. We're just going to presume that they all count. Detained pursuant to the AEA, we had to stop removing them, right? We were paused, says Trump. Now, that class consists of a bunch of people. It consists of all non-citizens in custody of the Northern District of Texas who will be subject to the proclamation. Now, that order that was issued before the lower courts addressed the number of issues in this case. In other words, the Supreme Court, you are overbroad in what you've done here, including propriety of class certification, the adequacy of the notice given to the putative class members, and whether they're even entitled to habeas, and whether emergency relief was warranted at all. So the Supreme Court basically, like in your order, you said, let's keep the status quo while a number of these issues are pending down below. But then you change the status quo. We can't even adjudicate all of these other things. Like, shouldn't we have an opportunity to say something about these matters? Now, intervening developments, writes D. John Sauer to SCOTUS, talking to you, Roberts, intervening developments make clear that neither interim nor permanent relief is warranted. So the pause here is unjustified because they're not going to win at the end. Now, the equities weigh particularly heavily against them, saying that these people are non-deportable. They're not going to win that. They say at a minimum, if you're going to allow this to continue, Judge, you should modify the temporary injunction to allow the government to remove these unlawfully present aliens pursuant to the non-AEA authorities, which applicants have conceded the government should be able to do. Now, first, writes D. John Sauer, intervening developments confirm that this class cannot even pursue a class action. It's not going to work that way. The district court on Friday, May 9th, denied applicants' motion for a class certification. They're saying, look, Judge, Supreme Court, another court has said that this can't survive. Now, you said we were going to pause this to let the lower courts settle this stuff. Well, one just came down and said that they're not going to win. So here you go. Now, as the court explained, they brought many independent claims, right? The lower level district court, they're like notifying the Supreme Court. They said they brought all these claims and blah, 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 class action. Now, that order confirms that these class members of this so-called class that you say are not the proper parties and are not entitled to any relief at all. Now, contrary to their contentions here, the Supreme Court should not treat the district court's denial of a class action as a denial. They lack any opportunity to address that issue as grounds for extending the injunction, right? They're saying, hey, just because they lost this down below doesn't mean that the status quo from you guys should stay the same. Actually, because they lost, you should change what you did, Supreme Court. Now, other developments also bear out the lack of grounds for relief from these ACLU gangbanger lawyers. It has now been more than 3 weeks since you, John, I saw you talking at that law school yesterday. Maybe you should review these cases, John. This court entered an order precluding the removal of all members of the class. Remember that 3 weeks ago? We're like, hello, what are you guys doing? Now, that 3-week time frame constitutes more than adequate opportunity to pursue judicial relief under any standard, okay? Plenty of pause time there. Thus, no class member now has any plausible claim of denial of notice or opportunity opportunity to be heard, all right? Now, you said pause it. 3 weeks, great. They all got notice. They've all had plenty of notice since the order came down, and so they should file their claims. So that's over now, so we can deport them. Now, meanwhile, the equities have also swung against relief. Homeland estimates that there are something like 176 class members that are a part of this so-called putative class. Now, because this court and you, Supreme Court, categorically prohibited removing any of them, you said we can't touch any of those 176 people, even under non-AEA authorities, right? If Trump can't use the AEA, well, what can't he just use regular immigration provisions? No, said the Supreme Court. Now, the government has been detaining these aliens instead of removing the many putative class members as you ordered. Now, unsurprisingly, given that the putative class members were detained based on their membership in a designated foreign terrorist organization, they have proven to be dangerous, especially in long-term detention. Some of these 23 class members recently barricaded themselves in a housing unit for several hours. They threatened to take hostages. They threatened to harm ICE officers in America. Now, as described in a declaration, it was all explained. So the idea of transferring these people to other facilities creates ongoing risks of prison recruitment and expansion of Tren de Aragua within the United States because they're here using these facilities as a base of operations. Now, that is an alarming prospect, especially given that Tren has conducted kidnappings, extorted businesses, bribed public officials, lived in casitas, authorized its members to eliminate law enforcement, and even eliminated opposition figures down in Venezuela. So, Supreme Court, given these developments, we, the government, request that the court lift your injunction that says we can't deport these people. The class members are not the proper parties to be certified as a class of gangbangers because there's no commonality between them and have received adequate notice and opportunity. So if you have any concerns about due process, well, they had 3 weeks. And the named petitioners here, AARP and the rest of them, have filed habeas petitions and have not shown an imminent risk of removal while those petitions are pending. So they can file and get their litigation, get their due process if they want. Now, at a minimum, this court should modify the administrative injunction to permit the removal of any aliens under non-AEA immigration authorities, right? So if we have another independent basis to remove them, let us. Here's why. Intervening developments, Supreme Court, writes D. John Sauer to SCOTUS, John Roberts in particular. They say, listen, in case you're not aware, on April 19th, you guys, the Supreme Court, in case you forgot already, you entered an order directing the government, don't remove anyone. And now what has happened is the district court where you said to send this back down to, they have responded. And guess what they did? They have denied their class certification because they're gangbangers and illegals. The putative class members are now confirmed non-parties to the case. So you accepted this case and issued a putative class, but in that case, the putative class has been dissolved. There isn't one. And they lack a sound basis for any more emergency relief here from you guys. And so what has happened is they sought relief on behalf of a class, and we've screamed about this for months now, a class consisting of all non-citizens who have been declared to be aliens and threats to the country under the AEA. Now, as the district court is now held, the lower level court, that amorphous class definition, what is it? What is the class, right? Like a normal class action would be like, oh, that one product burned me. Everybody who got a burn from that one product, it's pretty definite. It's pretty, numerous. There's a number of people who have it. They have a common injury or claim. Here, everybody's debating whether they're gangbangers or not. They're saying, no. I'm just a barber. I'm just a PhD scholar. I'm just trying to understand the nature of the universe in America. Critically, the class includes way too much variety. Okay, there's not a typical claim amongst them. As the court has explained, their due process claims were not typical of the class. Everybody is different. Everybody files their own, gets their own lawyer, files their own claims. One guy says, I'm not a gangbanger. The other guy says, okay, you got me. So it's different. They can't all make the same claims. The court recognized that those distinctions matters, and so you can't certify them as a class, obviously. And with respect to the habeas claim, the court also noted that they're going to have to present evidence individually, in particular to their case. So a class resolution can't solve all of their problems. The district court also found that the certification did not satisfy the rules. So somebody should tell that to Judge Boasberg, since he doesn't read the rules. The court noted that some petitioners may not be entitled to a writ of habeas, ordering their complete release if they are also detained pursuant to other provisions of the law. The court further declined to award sweeping injunction and said, you guys lose, explaining that their request would be more befitting of a lawmaker or an administrative agency. Yeah, judges can't do this crap where they just basically pass a law. Well, you now have legal status. Why? Because you're a class action and Trump is the president, not anymore. They exceeded the court's role. You can't just make that up. The district court finally explained, and even Supreme Court said this, right? It's a habeas petition, must be filed in the same district. That's where this is happening. And this is why they didn't want to file there. That's why they took this to Maryland with Judge Zenas and took this to DC with Judge Boasberg. The court explained you gotta file your own habeas habeas petitions. And the lower level court, Supreme Court, just in case you didn't see this, it confirms to you that you should not grant or maintain any relief to the class members. They want to file individually, that's fine. But Gorsuch said explicitly, under Article 3, courts may only grant relief to the parties that are before them. And guess what? The district court just said they're not a party to this case. They're not class members. Obviously. The same limitation applies to the authority towards granting relief here from you, Supreme Court. They're not members to your case anymore either. Now that they have been denied leave to represent the class members, they're not parties and they don't get any relief. And so we can take them out of here. This is especially true in light of the material differences as well. And so the class denial is correct. There is no reasonable prospect of reversal on appeal. So you can't legitimately say you're just going to reverse that and say that you can have a class action of people that are basically underwriting the rules. Not going to happen. Now, in their notice to the court that was filed yesterday, the applicants contend that this court's intervention is warranted because other districts have certified classes, right? Boasberg has said, oh yeah, total class of gangbangers. Even though I don't have jurisdiction over you, I don't care. I'm just going to violate what the Supreme Court said and just use my contempt power instead of my regular power in order to keep this case. But the certification of other classes in other districts does not change the fundamental fact that here in this case right now, they are non-parties to this lawsuit. Whatever they're doing elsewhere, we're talking about this case. If anything, the submission confirms that your examination of a class claim would be premature, right? There's like, say, see, over here they're doing it, but over here they're not. Now, applicants have not yet sought reconsideration on that appeal. Like they haven't appealed it yet. They just want you, Supreme Court, to maintain your order. But the basis of your order was to allow the lower courts to resolve this stuff. Now they've done that. Yet they ask this court to grant cert or otherwise provide guidance on class certification because they want to bypass the Court of Appeals, which they know they'll lose in. Such a circumvention of the court's ordinary procedures is unwarranted, given the dubious basis for this class in the first place. And in addition to the typicality problems, meaning the class don't have typical problems that are common amongst them, other classes also have defects, like numerosity. This court should reject this application and say that these class members and their reluctance or their disinclination to file their own habeas petitions underscores the impropriety of the proposed class, right? So the idea is, well, they don't need to file their own habeas claims because they're certified as a class, is what they would argue. But they're saying, well, you've given them 3 weeks. We haven't removed them. If they haven't filed a habeas petition yet and your stay is lifted, then they can't make a screeching claim that they didn't have notice or opportunity because they had 3 weeks. And it refutes any entitlement to emergency relief. We're going to get deported tomorrow. They're loading us onto airplanes. No, they're not. You've been sitting there for 3 weeks. Couldn't find a lawyer in 3 weeks? That's your problem. Now, in the Boasberg case, this is the Trump versus JGG case, Boasberg held that the detainees must receive notice that they're subject to removal under the AEA, and they must be given reasonable time and manner to actually seek habeas. And that's what the Supreme Court said, remember? Reasonable time to actually seek. Now, it doesn't say they have to be granted a hearing, and this decision has been perverted too by the mainstream media in many positions, saying, well, the Supreme Court said you have to give them due process and you have to give them a hearing. No, it didn't say that. Allows them to actually seek habeas if they want to. It's not a mandate. Applicants sought emergency relief from this court. They say, you didn't give our clients proper notice. We said, yeah, we did. We did give them reasonable notice and reasonable time to pursue habeas by virtue of the fact that they sued here today, right? We know they sued because we're in court. But at a minimum, they're not going to win on this injunction. And they've had 3 weeks to go get their lawyers. And 3 weeks is way more than reasonable time for them to file a habeas petition. In fact, the applicants in this case, they filed their lawsuit within hours of learning that the removal was being issued. So why do they need like months and 30 days and 6, however much time they're asking for to do it? They got 3 weeks. If they haven't filed, that's it. Detained aliens in other cases get way less than 3 weeks, by the way, too. 3 weeks here was more than adequate to pursue a habeas claim. But as far as the government is aware, no members of this class who have received notice have filed habeas petitions in this district. The day before this court's order, 2 class members filed a habeas petition, which they later sought to hold in abeyance because they said, oh, we don't want to pursue that avenue of litigation because they know that it might harm them. They'd rather just be protected under this fake class that these judges are certifying. But no others have followed the path in 3 weeks. They're just sitting there, just letting the ACLU say, don't file anything, right? This is a strategy, despite every indication they could do so if they wanted to. Now, the class and its counsel had reason because if they start filing individually, it's like strength in numbers. Then they said, well, see, they're all filing, so why do they need a class? So they're telling them probably not filed. The class and its counsel had a reason to expect that this would fail, and they should have been filing for the last 3 weeks. Now, at minimum, their failure to file their own petitions make it impossible to determine which one of them would handle their case according according to their own needs, and they can't turn around and claim that they've got inadequate notice. Now, they also say that notice must be in advance of at least 30 days. They say that there's this World War II era policy, something about the Germans or the Nazis or something. But they offer no basis for treating this policy different from the 1940s as a constitutional floor, even if you gave them 30 days. And here, the difficulties of these people detaining them when they're taking over prisons bolster the grounds for a much shorter notice period. But regardless, they've got 3 weeks, and that's plenty. Now, in addition, recent dangerous behavior of these gangbangers supports our claims. As the appended declaration explains, serious difficulties have arisen from keeping these gangbangers locked up. Here's why. As a general matter, Homeland is concerned about the prolonged detention because their gang is growing in numbers inside the prison population. The detention of these class members in this case is already posing dangers. In April, at the Blue Bonnet Detention Facility in Texas, illegals barricaded the entrance doors of their housing unit using bed cots. They blocked the windows. They covered their surveillance cameras. They threatened to take hostages. They were going to injure ICE officers and the facility staff. And the detainees refused to comply with orders to dismantle the barricades and more. Now, this court should not exercise its equitable discretion to prolong these detentions and to endanger other Americans. One of the key reasons the government has decided to use more expeditious procedures to remove these people is because they're dangerous. The recent episode at Blue Bonnet shows exactly that and why they have to go. Now, at a minimum, Supreme Court, you should modify your injunction to clarify whether we can remove people based on other authorities or if it's only under the AEA. According to your prior order, it's for everything. But they have confirmed they're only challenging the AEA and they're not contesting anything else under Title VIII. So why is the Supreme Court's order overbroad and protecting them on issues that they're not even raising? The difficulty of detaining the class members discussed here make this an imperative, and your injunction is stopping us from doing our jobs. Now, following the barricading incident, for example, we had to move them to a different location for dangerous detainees. And the vast majority of these people are eligible for removal even under Title VIII. Now, the government has a strong interest in getting this done quickly. They do not object to removals under Title VIII, so why can't we remove them under that provision, court? So what should happen is you should deny what they're claiming in full. They are not a class, and if you dismiss this class from your order, only the named habeas petitioners will remain and will get rid of everyone else. They got plenty of notice. They had plenty of opportunity to actually seek habeas, and that's what you mandated. And these named petitioners have not demonstrated any imminent danger warranting emergency relief at all. They don't contend they face imminent risk of removal while their habeas petitions are pending. If they filed a petition in habeas, we won't remove them. Applicants have not identified any further relief that they seek from this court on their own behalf, and the sole role they have sought from their initial application is relief only on behalf of non-parties who are a part of a putative, uncertified class. So kick out everybody who was bundled into this program and saying 3 weeks on, that relief is less warranted. They've had 3 weeks to get lawyers and file their own claims. They haven't done it. So you, Supreme Court, should deny the application and you should vacate your injunction that you issued 3 weeks ago. Signed by D. John Sauer, referencing this decision that came out in the WMM case out of the Northern District of Texas, saying, Supreme Court, we have complied with everything you said. Your order is overbroad. These are clearly not class members. The district court judge has now found that accordingly. You said to pause everything until we got that settled. It's settled. So now it's time for you to act. Now, we also saw in the Kilmar Abrego case, we had an update and an order from the judge. Judge Paula D. Zenas, rhymes with, out of the District of Maryland. She's very upset at the Trump administration. She said, pursuant to this court's order, Trump and the gangbang lawyers who were representing Kilmar wife beater Armando Abrego Garcia, human trafficker, they have filed simultaneous briefing and accompanying motions to seal, writes the judge. Bunch of stuff came in. But evidently missing from Trump's filing, she writes, is the privilege log that I ordered you to produce. I said this, on that same date, which was yesterday, the deadline, Trump shall provide the privilege log to the court. And so she wrote this today. She said, accordingly, Trump is ordered to correct this deficiency and file that log by 3 p.m. today on my desk, or else failure to file the privilege log or otherwise will be construed as an intentional refusal to comply with this court's orders. And additionally, we direct them, the gangbangers, to file their privilege log in discovery by 3 p.m. today as well. And again, this court says you must adhere to the local rules. If you want to seal these logs, file file a motion signed by Paula Zenas, ultra-lefty judge in Maryland. They forum shopped her, and of course, she is playing the game. Now, what we see is that the government did comply. They sent this in. They said, all right, look, here's our sealed response. Filing of the privilege log by Christy Nome, and the judge granted it. They said, we want to seal this, and filed a request to seal it. They say, you know, Trump says the following facts are justifying the sealing of this. Bunch of stuff is in here. Attorney's eyes only, confidential memos, interim sealing is governed by the rules. And so we ask you, Judge, to have this sealed because we're designating it confidential and attorney's eyes only. An Excel version of the document will be made available to the court for its convenience. They're like, we got to get this in. They're like, it's 2:58. Type it. He's like, I can't. I have to run a spell check. I mistyped convenience. It doesn't matter. Just submit it. Print it. Print it. And, you know, they file it and submit in PDF, and boom, there it goes. Publicly disclosing that information would likely harm ongoing diplomatic negotiations sent off into the court by Drew C. Ensign to Judge Zenas. So we'll see what happens on this one. But Zenas, of course, is trying to ensnare them. She knows she doesn't have any power to govern any of this stuff. She can't force Trump to engage in foreign diplomacy. She ordered them to effectuate the return of Kilmar. No idea what she's doing. And the Supreme Court issued a very waffly order on this case. Obviously, Kilmar Abrego Garcia, who's a wife beater, human trafficker, and worse, was in our country illegally and was lawfully deported to El Salvador. His withholding of removal said don't send him to Guatemala, and he's in El Salvador. There's no violation of his withholding of removal order. DOJ didn't make that argument because poison pill attorney Iraz Ruvani poisoned the case and then got fired for it in the aftermath. But the point is, Kilmar is right where he belongs and shouldn't be coming back at all. And if these judges don't get the message, don't get the memo that this is perfectly within the purview of the executive branch, as Stephen Miller says, there are other options available.
Whether the courts do the right thing or not, at the end of the day, Congress passed a body of law known as the Immigration and Nationality Act, which stripped Article 3 courts, that's the judicial branch, of jurisdiction over immigration cases. So Congress actually passed, it's called jurisdiction stripping legislation. It passed a number of laws that say that the Article 3 courts aren't even allowed to be involved in immigration cases. Many of you probably don't know this. I'll give you a good example. Are you familiar with the term temporary protected status, or TPS, right? So by statute, the courts are stripped of jurisdiction from overruling a presidential determination or a secretarial determination on TPS when the Secretary of Homeland Security makes that determination. So when Secretary Nome terminated TPS for the illegals that Biden flew into the country, when courts stepped in, they were violating explicit language that Congress had enacted, saying they have no jurisdiction. So it's not just the courts aren't just at war with the executive branch, the courts are at war, these radical rogue judges, with the legislative branch as well too. So all of that will inform the choices the president.
Habeas corpus may be something that is coming soon. Of course, we're going to keep our eye on this case and all the latest from Stephen Miller, the White House, and the Supreme Court. Will the Supreme Court act and settle this once and for all or not? We'll be here to cover it. Thanks for subscribing and joining as we do.